हाँ जी, गुड इवनिंग एवरीवन। जो लोग आ चुके हैं एक बार प्लीज मुझे फटाक से रिप्लाई कर दो, मैसेज कर दो, सो दैट आई कैन कम टू नो कि आप लोग ज्वाइन कर चुके हैं। दोस्त हु आर हियर ऑलरेडी, प्लीज मैसेज मी वंस सो दैट मुझे पता चले कि आप लोग आ चुके हो। मैसेज है मेरे पास संजय कुमार का, गुड इवनिंग सर। शिव कुमार, गुड इवनिंग सर। वेटिंग फॉर दिस, ऑल दोस्त हु हैव जॉइंड ऑलरेडी, प्लीज मैसेज मी वंस सो दैट आई कैन कम टू नो कि आप लोग आ चुके हो। Meha Jain, good evening. What about others? Waiting for your messages. मुझे याद है हमें यूनिट नंबर 6 से स्टार्ट करना है। हमें यूनिट नंबर 6 से स्टार्ट करना है। जो लोग आ चुके हैं एक बार जल्दी से मैसेज कर दीजिए सर, so that I can start with unit number 6, the important topics. मैसेज है मेरे पास रहीमा का, गुड इवनिंग। मैसेज है नंदनी का, गुड इवनिंग। जो आ चुके हैं जल्दी से वीडियो लाइक कर दो प्लीज। दोस्त हु हैव जॉइंड ऑलरेडी, जल्दी से वीडियो लाइक कर दो एंड लेट मी नो योर प्रेजेंस वंस यू आर इन, सो दैट हम जल्दी से स्टार्ट करें विद यूनिट नंबर 6 व्हिच इज कंटिंजेंट एंड कॉस्टली कॉन्ट्रैक्ट्स, एन इंपॉर्टेंट यूनिट जिसमें से यू कैन एक्सपेक्ट अराउंड 6 मार्क का क्वेश्चन एग्जाम के अंदर। पीपल आर स्टिल जॉइनिंग इन। डेविड जोएल, गुड इवनिंग सर। Around 6-7 messages already. That's it. In that case, हम जल्दी से स्टार्ट करते हैं फिर। Without waiting for anyone else, we shall start. Like I can see in the name itself, the whole topic is divided into two categories, which is contingent contract and the other one is quasi contracts. Contingent contracts and quasi contracts. शिवानी का मैसेज है, गुड इवनिंग। शिवानी गुड इवनिंग। ओके, जल्दी से स्टार्ट करते हैं। Let me tell you, June 24 के अंदर we had a question in the exam from the topic of contingent contract. In June 24 we had the question worth 6 marks from contingent contract. Sir, क्या एग्जाम में कौन सा क्वेश्चन आया था? In exam they asked us what do you mean by contingent contract, the definition. They asked for essentials and they also asked the rules. This was there in June 24. मैं फटाक से आपको दिखा देता हूँ एक बार आपके सामने ऊपर करके June 24 का पेपर। This is June 24 there in front of your screen. Okay, here we are. June 24. If I remember, it was question number 6. ये रहा सर। See, it was there in the exam worth 6 marks. Here's the question in front of you. The question says, what is the meaning of contingent contract? Write briefly its essentials. So this was the first half, meaning, second half, essentials, and they also asked the rules. So basically पूरा contingent contract इन्होंने पूछ लिया था एग्जाम के अंदर। एक बहुत ही ज्यादा इंपॉर्टेंट क्वेश्चन है with respect to quasi contracts. मैं आपका लेक्चर आज वहीं से स्टार्ट करूंगा। Although quasi contract से एक प्रैक्टिकल क्वेश्चन आ चुका था in the last exam, which was your question number 1 itself. ये भी आपके सामने ओपन कर देते हैं सर in front of you. Good evening, general contents. Okay, this is your September written paper, as you can see, and this was the paper again from quasi contracts. सर कौन सा क्वेश्चन था ये? दिस क्वेश्चन वाज बेसिकली पेमेंट बाय इंटरेस्टेड पर्संस. दिस वाज सेक्शन नंबर 69 ऑफ इंडियन कॉन्ट्रैक्ट एक्ट, व्हिच वाज बेसिकली पेमेंट बाय इंटरेस्टेड पर्संस. द क्वेश्चन दैट आई एम एक्सपेक्टिंग इन योर एग्जाम वर्थ 4 मार्क्स. ओके, आई विल टेल यू अगेन. द क्वेश्चन दैट आई एम एक्सपेक्टिंग फॉर 4 मार्क्स इन योर एग्जाम इज द मीनिंग ऑफ quasi contract and its features. This is the question that I am expecting in your examination. Guru S, yes, we are communicating in English only, so don't worry about that. The first important question for the day expecting in your exams is, what do you mean by quasi contracts and what are the essential features of a quasi contract? And this question can be asked for 4 marks. So we are starting right now with this question itself. I guess we all know a bit about quasi contracts. It is basically an implied contract without any words, spoken or written, is basically quasi contract. It is similar to a contract, that is why the word quasi contract. See, if you want to have a grip over the concept of quasi contract, you should know what exactly is the meaning of the word quasi. What is the meaning of the word quasi? Quasi basically means not exactly but apparently. Not exactly but apparently. As in, like a normal contract, we don't have offer, we don't have acceptance, we don't have consideration, nothing is there. We don't have promise, we don't have agreement, nothing like that. But still the lawmaker says that no, we are saying that there is a contract, and hence the word quasi, not exactly but apparently. हिंदी में बोलते हैं नहीं है फिर भी है. That is what we mean by quasi contract. Now coming to the features, we basically have three features as far as the quasi contract is concerned. The very first feature is, sir, it is right to money. The second one says imposed by law, and the third one says right against a particular person. So we basically have three features. Number one, I'll repeat myself. I'll give you an example. I'll give you a very good example, but focus on the words right now. The first word that I said, the first feature that I said was that it basically is a right to money. The second one that I said was it is imposed by law. And the third one that I said was it is a right against a particular person. Now I basically want to give you a very good example about the quasi contract, which will help you to remember all the features of quasi contract. So let's come to the example directly. We are right now, I can see around 20 on YouTube and hundreds of them on Zoom Live. Those on YouTube, there's a request that in case you have joined in, you need to let me know that you are here, and please like the video in case you haven't liked the video. I am coming directly to the topic, which is features of quasi contract. I'll write the features first and then we'll come to the example. I'll write the features first and then we'll come to the example. This is 4 marks which I expect will be there in your examination. I expect this to be in your examination. The number one feature, I'm writing in short, right to money. Second one, imposed by law. And the third one, right against a particular person. Okay, very easy. You write this and you have to get full marks. Sir, important questions in unit number 5. I think we discussed it already in the last session. Important questions of unit number 5. General contents, we did discuss this in the last lecture. Important questions of unit number 5. I think I told you already that for your exam, the important question is, what do you mean by anticipatory breach of contract and what are the effects of anticipatory breach of contract? I'll come to that again, don't worry. I'll come to unit number 5 again, don't worry. Okay, right now over here. Starting with an example. Okay, I'll keep this in front of you, there in front of you, and I'll give you a very good example to understand the same. Starting now, let's say we ordered a pizza from Domino's. We ordered the pizza from Domino's and we gave the address, and let's say the address was incomplete. It was 4th floor, comma, XYZ apartments, comma, Azad Nagar, Andheri West. Okay, so we basically typed this address of ours, that 4th floor, XYZ apartments, Azad Nagar, Andheri West. This was the address that we filled in. Now, the Domino's guy came to the building and he basically saw that there are 2 houses, 401 and 402. This was our house. This was our neighbor, Bajuwala. Okay. Now because we had not written 401, so what happened is Domino's basically went to 402, asked our neighbor that did you order the pizza? The neighbor said, is the order already paid? Domino's said yes. And my neighbor basically took the pizza and closed the doors. Now I was still waiting for the pizza to be delivered. Now ultimately when it was already half an hour, 45 minutes, I called Domino's and asked Domino's that where is my pizza? And Domino's tells me that we have already delivered your pizza. So I asked, where did you deliver? The Domino's guy says, sir, we delivered 402 के अंदर we delivered the pizza. And I was like, okay, by mistake they have delivered it to my neighbor. So I basically ring the doorbell of my neighbor and ask the neighbor, where is my pizza? The neighbor says he has already eaten up the pizza by himself. So I am here hungry, waiting for my pizza, and my neighbor tells me that he has already consumed the pizza. I was like, okay, fine. What you can do is you can order pizza for me, it's fine, or you can pay me for the pizza. Now my neighbor says, no, neither I will order the pizza for you, nor I will pay you the money. Now I'm asking, why are you saying so? You did consume my pizza, why are you now denying to order a pizza for me or to pay for the pizza for me? My neighbor says, see, we didn't have any contract between us, me and my neighbor, we didn't have any contract, as in me and my neighbor never talked that in case my pizza gets delivered to your place, please give it back to me. Or if your order comes to my place, I will deliver it to you. Like we never had a contract. If I happen to go to the court, the judgment will be in my favor. The law will say, although there is no contract between me and my neighbor, yet the lawmaker says, no, we are by law imposing on my neighbor a contract that he has to pay for the pizza to me. And hence your second point is reconciled, which is imposed by law. Although there is no contract as such between me and my neighbor, but still the law is saying that no, there is a contract. Sir, what exactly? The neighbor has to either order a pizza for me or he has to pay me for the pizza, which is right to money. And this right I have only against my neighbor, which is right against a particular person, which is right against a particular person. So basically with my example, all I'm trying to do is reconciling all the features so that you don't mug up the features and learn it conceptually that, okay, sir, the features of quasi contract are just three, which is it is a right against a particular person, it is a right to money, and the last one, it is imposed by law. Sir, where is it exactly in the textbook? I'll just show you up. Here we are, quasi contract, and here we go, the features. Salient features of quasi contracts. I'll mark the things for you. The first one, right to money. Second one, imposed by the law. And the third one, a right which is available not against all the world but against a particular person, which in my example was my neighbor. Which in my example was my neighbor. And this sums up the features of quasi contract along with the example that I just gave you. Here we are. Please tell me, are we clear with this much? Please tell me, are we clear with this much? All those who are there online, on YouTube, on Zoom, please tell me, are we clear with this much? The features of quasi contract were 4 marks, very much expected in your examinations. Are we thoroughly clear? Can I assume that you now remember all the 3 points rather than mugging up things? You now know it conceptually. Are we clear? Are we clear? I am waiting for your messages. Are we clear? Okay, message from Jay. Yes, sir. Meha Jain says yes, sir. Abdul says yes, sir. Shivani says yes, sir. Guru says no, sir. Guru, tell me what you did not understand. Tell me, please. Sangeeta says yes, sir. Sir, Kiran says third one is not clear. So basically, I can ask for the money of the pizza only from my neighbor and nobody else. Are you able to understand, Kiran? I can ask for the money only from my neighbor and nobody else. And that is why I write against a particular person, which is in my example, my neighbor. Kiran, I hope now we are clear. Nandini says yes, sir. General content says yes, sir. Thumbs up. Okay. Around 9, 10, 11 messages already saying it to be clear. Kiran, I hope we are clear now. So I'll now mark up. Guru says yes, sir. Okay. So I'll now mark up for you the quasi-contract theory which you need to write in the exam in order to score full marks, that is full 4 marks. Let me start for you. You can mark it along with me, obviously. A valid contract. Can you take your mic near? Yes, it is already near. I should be properly audible, isn't it? Okay. I've kept it more near now. Okay. So it says a valid contract must contain certain essential elements such as offer and acceptance, capacity to contract, consideration, and free consent. Now I will start to mark. Sometimes the law implies a promise imposing obligations on one party and right in the favor of the other party, even when there is no offer, no acceptance, no genuine consent, no lawful concession, etc. And in fact, neither agreement nor promise. Next, such cases are not contract in the strict sense, but the court recognizes them as relations resembling those of the contracts. Hence the term quasi-contracts, that is resembling a contract. This much you need to write in the examination. This much you need to write in the examination. In case you can remember one more line, I would underline quasi-contracts are based on principles of equity, justice, and good conscience. So this much in theory, and the features. And you have to score 4 out of 4. The first question of the day with respect to your January 2025 attempt, we have completed. The first question worth 4 marks, very important for your exams, we have completed. He has given me cases which are deemed to be quasi-contract. This was there in September 2024. This was there in September 2024. And if you can recall, please let me know in the chat box. If you can recall, we have already done one of the question with respect to section number 68. If you could remember, the question was, there was a grandmother, there was an unsound person, the grandmother was dependent on the unsound person, then the expenses were done with 15 lakhs, we had only the gold worth 4 lakhs, we also had a house. Can you recall that example of mine, the question that we did in the class? That was section number 68. So 68 was there already in the exams in the past. 69 was already there in September 2024, and the rest ones are anyway very easy. Even 71 was there in the last attempt, which was responsibility of the finder of goods, and these two are anyway easy. Meha Jain says yes, sir. Okay, thank you. I'll move directly towards the next point. 68 we have discussed already in the last class. This was there in September attempt, it won't come again. This is easy. Obligation of person enjoying benefits of non-gratuitous act. See, gratuitous basically means something done for free of cost, something done out of love and affection. So in my pizza wala case, it was not a gratuitous act, and hence my neighbor has to pay for me. Fourth, easy again, it was there in the last exam, and fifth is anyway easy. So what you need to know is this much, only and only this much for your January attempt. I'll directly shift towards contingent contract. Important again, not very important, but yes, I would say that you must do at least the basics of the contingent contract. Let's start with the definition, which basically says a contract to do or not to do something if some event, a very important word, collateral, to such contract does or does not happen. Okay, I'll repeat the definition. Again, I want you to understand the concept, the logic, so that we don't have to mug up the things. So it basically says a contract to do or not to do something if some event collateral to such contract does or does not happen. Let's take an example. I want you to focus on the word collateral. Okay, this is very important. This collateral word is very important as far as contingent contracts are concerned. This is very important. The word collateral is very important. Let me give you an example. Let's say I approach an insurance company. I approach an insurance company, and basically we have a contract whereby I have taken a car insurance. I have taken a car insurance. Now, as per the contract of the car insurance, I need to pay premium. I need to pay the premium, and the insurance company will give me protection. Protection as in case your car meets with an accident and you happen to suffer a loss, we will compensate the loss, and that is what is contract of indemnity. So basically the contract goes like this. I will draw a box. So this is the contract that I will pay the premium to the insurance company and they will basically give me protection. Protection against what? So basically protection against car accident. Now I want you to drag your attention towards the boxes which I have strategically made. The two boxes are basically separate from each other. The car accident is not part of the contract. It is not part of the contract. This is basically collateral to the main contract. This is basically collateral to the main contract. As in, I am not supposed to make my car meet with an accident. No, this is not what the lawmaker is saying. The lawmaker is saying, in case your car meets with an accident, we are here to indemnify you. We are here to protect you. But the accident of the car is not part of the contract. It is collateral to the contract. And that is what the lawmaker is saying. Here we go, one more time, one last time. A contract to do or not to do something if some event collateral to such contract does or does not happen. So this was the best example to understand the word collateral. So what if I happen to do an accident of my car intentionally? In that case, insurance company will not indemnify you. Insurance company will not pay for the losses. It is only if the car meets with an accident without your fault, the insurance company will pay you. So the accident is not part of the contract. It is collateral to the contract. So this was something important. This is something I told you right now, meaning of collateral event. This is something I just discussed with you. Now what is important is, apart from the definition, what is important is the essentials and the rules. As far as essentials are concerned, we have 4 essentials and we have 6 rules. So you need to have this much in your mind that as far as contingent contract is concerned, we have 4 essentials and 6 rules. See, rules has been asked many times in the exam. Rules has been asked many times in the exams. So I want you to focus right now first on the rules of contingent contract. So let me start quickly without wasting any time as far as the rules are concerned. Rules governing contingent contracts. Number 1. Sir, contingent upon an event happening. The first rule, contingent upon an event happening. So just write event and a tick mark. Remember it. Contingent on an event happening. Number 2, contingent on an event not happening. So exactly opposite of each other. So point number 1 says contingent on an event happening. Point number 2 says contingent on an event not happening. We will take examples obviously, but right now let's try to understand the head points. I'll come to point number, not 3 right now, 4 first. Sir, contingent on an event happening within a fixed time. So it is so similar to point number 1. Contingent on an event happening within a fixed time. The fifth one, contingent on an event not happening within a fixed time. So easy it is to remember. So easy it is to remember the point. Yes, sir, these are event happening, event not happening. These are again event happening, event not happening. But this time they have given the time element. This time they have given the time element. So I guess out of the 6 rules that we have, 4 of them should be very clear. 4 of them should be very much clear. Now let's come to point number 3 and point number 6. Point number 3 and point number 6. I'll come to point number 3 first. I'll write 6 also. Both of them are very much similar again. Both of them talk about uncertain event. Both of them talk about uncertain event. Something I would say impossible event. So 6 says, third again says, but this time we have one more point which says person. And we are at point number 3 and 6. Now let's come to the point. Point number 6 says contingent on an impossible event. I use the word contingent first and then I use the word impossible. So now I'm combining both of them. Contingent on an impossible event. I guess we all know this. In that case, the agreement is void. In that case, the agreement is void. Point number 3 is a bit longer as far as the head point is concerned. So contingent on a conduct of a living person when that living person does something to make the event or conduct as impossible. So what is common is both the point has the word impossible. This has again impossible and this has again the word impossible. This has event not happening, this has event not happening. This has event happening, this has event happening. So it is so easy for you to remember it like this way, the way I am trying to teach you. That's how you can remember every point in one go. And it's so easy to remember if you study the way I am trying to teach to you. Let's come to the points quickly. Here we are. Rules. Rules relating to enforcement. Rules relating to enforcement. The first one. I'll mark the point for you. Enforcement of contracts contingent on event happening. In the same sequence which I taught you, contingent on an event happening. B, contingent on an event not happening. Exactly the opposite. Exactly the opposite. Let's come to example. A contracts to pay B a sum of money when B marries C. So this is the event. This is the event we are talking about. This is the event we are talking about. A contracts to pay B a sum of money when B marries C. C dies without being married to B. The contract becomes void, obviously, because the marriage is now not possible. So the contract was basically contingent on an event happening, which was the marriage. Second one, enforcement of contracts contingent on event not happening. Let's come to the example. Where P agrees to pay Q a sum of money if a particular ship, I'll mark for you, does not return. This is event not happening. See how I'm trying to correlate things to make it so easy for you. Where P agrees to pay Q a sum of money if a particular ship does not return. The contract becomes enforceable only if the ship sinks, so that it cannot return. Easy, I would say. And directly jump to point number 4 and 5. Here we are. Contingent on happening. See again the word happening. Happening of a specific event within the fixed time. And the fifth one, contingent on specific event not happening again within a fixed time. So easy it is to remember all the rules. Now if I read the examples, example 12 says A promises to pay B a sum of money if certain ship returns within a year. So I'll mark it for you. Certain ship returns. This is happening within a year is the fixed time. Easy. Fifth point, example, A promises to pay B a sum of money if a certain ship does not return. This is not happening within a year, within fixed time. Are we clear with these 4 points? Please tell me first. I'm trying to correlate things so that we understand the concept logically, conceptually, and remember it forever. Please message me. Are we clear with point number A and B, point number D and E? Are we clear? I will wait for your messages. I will wait for your messages. Are we clear with this much? Are we clear with this much? General content says yes sir. Okay, thank you. Others, I hope my efforts of trying to make you learn things logically, it is helping you, and in case it is helping, please let me know through a message so that I can come to know that my efforts are being in a good direction. Are we clear? I go towards point number C and point number F lastly. Like we all know already, both the points are with respect to impossible event. Okay, I have a message from Guru who says yes sir. Shivani says yes sir. Okay, so impossible event here also, and point number C again has impossible event. Here we go. So point number C and point number F are related. Let's come to point number F first. Contingent agreements to do or not do anything if an impossible event happens are void. We'll quickly do an example. Example number 14. A agrees to pay B rupees 1 lakh if sun rises in the west next morning. I guess we all know this, that this is an impossible event. So what is the conclusion? The agreement is void. Agreement is void. So easy it is. I'll come to point number C, which is a lengthy head point, I would say, but then again very easy. Here we go. Contingent upon the conduct of a living person when that living person does something to make the event or conduct as impossible. Let's see an example. Where A agrees to pay B a sum of money if B marries C. Okay, sir. What next? C marries D. Now this is that point. Living person does something to make the event or conduct as impossible of happening. This is that point. So basically, if you are talking about A paying money to B if B marries C, but what happened was C marries D. So because of C, because of this C, the event of B marrying C has become impossible. B marrying C has become impossible. And we're done with the example. And we're done with the topic as well. The topic of enforcement rules, contingent contract. A, B, C, D, E, and F. I tried to correlate things to make it very much easy for you, and these were the points. Try if you can recall these points. Can you please try for a second, a moment? Take, give yourself a moment and try to recall if you can come out with all these points in your mind. Where the first point said something about event happening. Point number 2 said something about event not happening. Point number 4 said event happening within a specified time. Point number 5 said event not happening within a specified time. And point 3 and 6 are discussing about impossible event. In point number 3, the event was impossible since the beginning, void agreement. And in point number 3, it became impossible because the conduct of a living person. So the common point is impossible and impossible. Are we clear? Are we clear? We have done 3 questions till now. It is not even half an hour that we started the lecture, and we have done 3 good questions. One of them very important, which was quasi contract and features. Then we did meaning of contingent contract. Then we right now did rules regarding contingent contract. 3 questions we finished in a span of 30 minutes. Please tell me if you are clear. The topics done. The 3 topics are done. Unit number 6, every important topic is done already. Are we clear? Are we clear? Basically, I taught you the whole of unit number 6. Only one point is left, which is essentials. Only that is left. But till now, are we clear? Are we clear? All of you which are there online watching live streaming, are we clear? 3 questions. Quasi contract and features, meaning of contingent contract, rules regarding enforcement of contingent contracts. 3 questions. I hope we are clear. Waiting for your messages so that I can come to the last question that we have, and the unit number 6 is over already, which is essentials of contingent contract. Only this is left, and we are thorough with the whole topic. Let me start. We have basically 4 essentials, and out of 4 of them, we already know point number A, point number B, and point number D. 3 points we know it already. Let me open it for you. Here we are. Essentials. Essentials. रिमोट तो ना एसी का नहीं है, गर्मी हो रहा है, रिमोट ही नहीं, या नीचे देखो पूरा हो रहा है. The topic says basically essentials of contingent contract. Like I said, out of 4 points, we know 3 points already. Let's discuss those 3 points first. The first point, C, we know it already. Contingent contract would depend upon the happening or non-happening of some event or condition. You can take the example of the car accident. Now the car accident may happen, it may not happen. So contingent contract would depend upon happening or non-happening of some event or condition. So we know point number A already. Let's quickly move towards point number B. Again, something we know already. Event referred to as collateral to the contract. Remember my example of car accident? Remember my example of car accident? This was this. Collateral. This was collateral. This is collateral. So easy. So A and B we know already. I'll come to point number D, which again we know. Here we are. The event must be uncertain. Then only you can say it to be contingent. Obviously, the event has to be uncertain. Then only we can use the word contingent. So with respect to point number A, B and D, you should not have any problem. With point number A, B and D, you should not have any problem whatsoever. Let's jump to point number C. It says a bit tricky. You will need to focus a bit more. It basically says contingent event should not be a mere will of the promisor. Contingent event should not be a mere will of the promisor. Let's read. A very good example we have. The event should be contingent. The event should be contingent in addition to the will of the promisor. Let's come to the example. If A promises to pay B rupees 1 lakh, if he so chooses, no sir, this is will, this is will, this is not done, this is not contingent contract, because the head point says event should not be a mere will of the promisor. So if the example goes like this, if A promises to pay B rupees 1 lakh, if he so chooses, now this is outright your will, this is not done, sir, this is not enough. Then let's come to the next part, the last part, a difficult part. It says where the event is within the promiser's will, but not merely his will. It may be a contingent contract. That basically means the event we are talking about is not fully in your control, because if the event is fully in your control, it is not contingent contract. So what we are trying to say is a part of it has to be uncertain, a part of it may be certain in your hands, but a part of it has to be uncertain, which is not in your hands. Example is very good, that is given over here. If A promises to pay me ₹1 lakh if it rains on 1st April. Now see, this is something which is not merely his will. And A leave Delhi for Mumbai. Now this is within will. Now this is within the will. But the lawmaker says this is allowed, this is okay. A part of it is in your control, in your will, and the part of it is not in your will. In that case, it may be a contingent one. So this was your point number C. All you need to do is remember the head point which says the contingent event should not be a mere will of the promise. And then. So sir, all the 4 topics are done, and we exactly took 35 minutes. We took exactly 35 minutes to learn and understand all the topics. If you would do this on your own, it will take you around 1.5 hours to 2 hours. Now, because we are doing it together and I'm constantly repeating the topic and making charts and diagrams, it is very much efficient, and it took us 40 minutes, 35-40 minutes to complete the whole of it. So which topics? Meaning of quasi contract and the features. Let's recall that one more time. Sir, right against a particular person imposed by law and right to money. Then we have meaning of contingent contract. Then we have rules of contingent contract, and we have essentials of contingent contract. So basically, see the efficiency that which what we are working. That's why we have done 4 questions in a span of 35 minutes. Are we clear? Are we clear? Waiting for your messages. Are we clear? 4 questions, merely 35 minutes. Expecting that you have understood this, expecting that you liked it, and expecting that you will now remember this forever. Please tell me, are we clear? I will wait for your messages. Everyone who is there online on YouTube, around 15 of them are on YouTube and around hundreds of them on Zoom live. General content says yes sir. Okay, with confidence, yes sir. Others not very sure. I'll quickly jump to the next unit, and in case you have missed this, you'll miss it forever. So you need to tell me if you have understood this or not. I have a message from Sangeeta who says clear sir. Okay, okay. That's it. Shall I move forward? Shivani says clear sir. Okay. Shivani says clear sir. Okay, fine. Let's move forward then. Let's move forward then. Unit number 6 is done. Unit number 7. Unit number 7. Let me remind you. Unit number 7, 8, 9 are the most important units. Unit number 7, 8, 9 are the most important units. But my problem is, if you do not participate, I'm only getting 3 to 4 messages. If you do not participate, I will not come to know if you have understood or not. So if I'm asking you, you need to let me know if it is clear or not. Okay, moving forward. Contract of indemnity and contract of guarantee. See, I'll basically give you a layout. I will basically give you a layout. The first part is contract of indemnity. All we have is just 2 sections. We have, as far as sections are concerned, 124 and 125. That is it. All we have is just 2 sections, 124 and 125. As far as contract of guarantee is concerned, the sections start from 126 and go till 147. Amongst these sections, what I'm trying to tell you is you must remember section number 126. Sir, with respect to the contract of guarantee, this is the first section. 126 is the first section of the whole topic of contract of guarantee. So it is so obvious that the first section has to be the meaning of contract of guarantee. So simple it is. If in the whole topic, if the list of section is 126 to 147, then obviously the first section, which is 126, has to be meaning of contract of guarantee. I am trying to make you remember section numbers. If you go to 124 and 125, I guess we know it already that 125 was there in your exams already in the last attempt. I still remember it was question number 6B. It was question number 6B, page number 12. Here we go, page number 12. Page number 12. Here we are. This is 125. So 125 was basically asked in the last examination. Obviously, very less chances that it will be asked again. Okay, almost zero chances. Let's study this anyway. (124) obviously you need to remember this also. Again, just two sections in contract of indemnity, 124 and 125. Obviously 124 would be the first section, would be meaning of contract of indemnity. Meaning of contract of indemnity. Let's start with the same example, obviously. And the example is again the same as we did in contingent contract. That's we have a car and we have car insurance. We have car insurance. In case we meet with an accident. In case we meet with an accident. It is so obvious, whatever loss that we have suffered, okay, let's say this part is damaged, whatever loss we have suffered, the amount will be reimbursed, compensated by the insurance company. And that is what is contract of indemnity. That one party is basically protecting you from loss caused to you by the conduct of any person. Although it also covers by the conduct of officer himself, but right now we're discussing by the conduct of any other person. This is that any other person. So whatever the damage the car has suffered, that amount will be reimbursed to you by the insurance company. And that is what is contract of indemnity, section number 124. Here we are. Need to remember this. It says the term contract indemnity is defined under section 124 of the Indian Contract Act. It is a different color. Contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person. We already took the example of any other person. Now, because this definition is not very important for your attempt, we are not going very much in deep. All you need to know is that, sir, this contract of indemnity basically is security against loss. Just remember car insurance. This is to make good the loss. Whatever loss you have suffered will be given to you. I would say in simple English, to compensate the party who has suffered some loss. Should be 110% clear till now. That is your 124. 125 was there in your last attempt. It will not be asked again. This is 125. It was there in the last attempt, will not be asked again. It was there for 2 marks. All you had to remember was all C, D and S. All C, D, S. Let's start with the C part. C says all costs. D says damages. S says sums. So basically all costs, all damages and all sums. This is all you have to remember to write in the exam. So obvious, sir, as far as the costs are concerned, we are talking about the litigation cost. We are talking about litigation cost. Sir, what litigation cost exactly? See, if someone has filed a case against you, you will defend the case. Or it may be possible that you are the one who is filing the case. In either scenario, you will need to incur legal expenses, and that is what is point number 1. All costs, which is basically legal expenses. Next one, all damages. Damages in what you are paying to the other party. What you are paying to the other party is damages. The lawmaker says in the book, all damages which a person may be compelled to pay as damages. And the last one is sums, which is basically compromise, which basically means outside the court settlement, whatever the settlement is and whatever the amount is being paid will be reimbursed. And hence the point all CDS. All costs, all sums, all damages. As far as the costs are concerned, this is bringing or defending the suit, which is legal expenses. As far as the damages are concerned, which you are compelled to pay. As far as sums are concerned, compromise in the suit. That is it. This is only this much is contract of indemnity. Only this much is contract of indemnity. So when does the liability of the indemnifier commence? It will commence when the liability is absolute and certain. When I say absolute, it basically means we have a concrete figure. Certain basically means the court order has arrived. Okay, let's come to the important part. Contract of guarantee. A very big topic, important topic, and very much concepts are there in this topic of contract of guarantee. So all I want is your utmost attention. I will make sure that I try to make you remember everything that is there in this topic. So all I want is your 100% attention and your messages when you have understood the concept. And if you haven't understood the concept, you tell me that, sir, please repeat, and I'll repeat it for you. Okay, let's come to the example first. I have a space over here. So we basically have a guy, Mr. A. Mr. A approaches Mr. B. Mr. A approaches Mr. B. Mr. A is asking to Mr. B that, sir, can you please provide me a loan? Can you please provide me a loan? Mr. A is asking this to Mr. B. Can you please provide me a loan? Mr. B says no. Mr. B says no. I will not provide you with the loan because I feel that you might not repay the loan. I feel you might default the loan, and hence I am not interested to give you the loan. A says, but I am very much in need of money. If you can please help me. Mr. B says, okay, let's do one thing. Give me something as collateral. Give me something as a security. Maybe a furniture, maybe a car, maybe your shop, anything. So that I can be assured that when I ask for the money, I will be paid back the money. Mr. A says, no, I don't have any asset, any property which I can give it to you as a pledge. Hence, Mr. B again says, so in that case, I will not give you the loan. Now, Mr. A is very sad. Mr. A approaches Mr. C. Mr. A approaches Mr. C and tells to Mr. C, can you please on my behalf give a surety to the Mr. B that you are there in case of my default. So accordingly, Mr. C goes to Mr. B and gives a confidence, gives a promise, a confidence, which says, please Mr. B, give the loan to Mr. A. C saying to B that please Mr. B, give the loan to Mr. A. He will repay you back. And in case he does not happen to repay back the loan, I am here sitting Mr. C, I will make sure that I will repay you the whole of the amount. So basically C is giving confidence to Mr. B to give the loan to Mr. A. Now Mr. B is very much assured. That okay, I have Mr. A already who is liable to pay me back the money. And if Mr. A does not pay, I have Mr. C who is there, standing there, promising me that in case A does not pay, Mr. C will. So now Mr. B is very much assured that his money is not in danger. Mr. B is very much assured that his money is not in danger. And accordingly, now Mr. B gives the loan to Mr. A. Accordingly, now Mr. B gives the loan to Mr. A. If I happen to name these people for you, it would be principal, debtor, it would be principal, debtor, this would be creditor, and this obviously would be surety. So three people I have named it for you. The word principal because he is the one, Mr. A, who is primarily liable to repay the money, and hence the word principal, debtor. See, both of them are debtors ultimately, but this one is principal, debtor. He is bound to pay prima facie the loan back. So A is principal, debtor, who is taking the money. Mr. B is the one who is giving the money, hence creditor. There is Mr. C who is promising to pay in case of default of A, and hence I will name Mr. C as surety. In layman language, we happen to say him as guarantor. But let's call it as surety as per your book. So this was the base. Let's dig a bit further. So what I can see is there are in fact three contracts. This is one of them, which is primary contract, or you can say it as principal contract, whatever you like. Let me write primary contract. Then what we have is a secondary contract. Here we go. Between these two, we have a secondary contract. So why are you referring this as secondary contract? See, this secondary contract will be invoked. This will be invoked only if debtor fails to pay. Then only we'll come to this part. And hence the word secondary contract. Last one, which is an implied contract. You can also say it to understand CAFC contract, which is between these two. Which is implied contract. So why are you referring to this as implied contract? Sir, it is so obvious that if surety is made to pay the money to the creditor, he will recover it from principal debtor. Because it was principal debtor who was initially primarily liable to pay the money. Now because he did not pay, surety had to pay his money. So this surety will obviously recover the money from principal debtor. So basically three contracts: primary contract, secondary contract, implied contract. One more thing I can deduce from this topic is, so this is a tripartite agreement. This is a tripartite agreement. As in, there are three parties involved: principal, debtor, creditor, and surety. Sir, this was the base for the whole unit. This was the base for the whole unit number 7. Please tell me, are we clear with this? Please tell me, are we clear with this much? This was the base for the whole unit number 7. Are we clear with this much? Are we clear with this much? I will wait for your messages. I will wait for your messages. We had Abdul Rahman saying, yes, sir. Okay. Waiting still. General content says, yes, sir. Nandini says, yes, sir. Sangeeta says, yes, sir. Okay. Around 4-5 messages. Shivani says, yes, sir. Okay. That's it. Around 5-6 messages. Others are zombie in that case. We shall move forward. We shall move forward. Okay. Okay. So this much we have already discussed. Here we go. This much we have discussed already. We have discussed also this already. General content says the most important unit number 7, 8, 9. As and when we move forward in the unit, I will tell you that this is more important. So general content, don't worry. Don't be so myopic. Think a bit bigger, a larger, a bit wider. That's okay. We are trying to get the concepts clear. And in case, meanwhile, if anything important comes up, shows up, I will tell you it is important. But right now, not focus on the important part, because ultimately in examination, any question can be asked. So think a bit wider. I'll tell you that, okay, this is more important, give it a bit more focus, but ultimately we have to study everything, okay? Especially unit number 7, 8, 9. I did not say this for unit number 1 to 6, but I'm saying this for unit number 7, 8, 9, because these 3 units are anyway very important. Okay, general contents, I hope I'm very much clear with my communication with you. So we're done with this page already. Moving forward. Essential features of a guarantee. Basically, we are given with 6 points. We are given with 6 points. You should at least know the head points. You should at least know the head points. Not very important, but like I said, we'll discuss the whole of it. Not very important, but can be asked in a theory question, maybe for 4 marks. Essential features of a guarantee. So obvious, there has to be a principal debt. There has to be a principal debt. There has to be a purpose. There has to be consideration. 3-4 easy points. 3 easy points. Fourth, we had a question from this in June 24. We had a question from this in June 24. Sir, what is the topic? The topic is no misrepresentation or concealment. No misrepresentation or concealment. This will come again. Fifth, writing not necessary. Writing not necessary. And the last one, joining of another co-surety. Joining of another co-surety. So you basically have these 6 points. Know the head points at least. Less chances in the exam, but like I said, we will cover everything. So purpose is there, consideration is there, existence of liability is there, no misrepresentation or concealment, writing not necessary, and joining of other co-surety. Now, out of all these points, point number 4 will get repeated. Important. Point number 4 will show up again. Point number 4 will show up again. Point number 6 will show up again. So these 2 are important. So general content for asking me which is more important. So see, 4 and 6 are very important, because both these points will be coming up again when we're discussing topic called discharge of surety. Okay, so these both of these will come again. Okay, moving forward. Types of guarantee. Types of guarantees. We basically have 2 types of guarantees. One of them is specific guarantee and the other one is continuing guarantee. Specific guarantee and continuing guarantee. Let's take an example. let's say this is me, Vishwanath Sharma. This is me. I have a shop besides my building, and I am expecting my cousin to show up at my place for a few days. I'm expecting my cousin to show up for a few days at my house. Now I know it already beforehand. I know it already beforehand that my cousin is addicted to Red Bull. I'm aware of this beforehand that my cousin is very much addicted to Red Bull. So basically, as a courtesy, what I'm doing is I'm going to the shopkeeper. I'm going to the shopkeeper and telling him that see, my cousin might show up to purchase Red Bull. My cousin might show up to purchase Red Bull. Most probably he will pay it himself. Most probably he will pay it himself. But in case he does not pay, don't ask for the money from him. I will pay. I will pay. So I am telling the shopkeeper that my cousin will show up and might consume one Red Bull. He will pay it himself. But in case he does not pay, please don't ask for the money from him. I am here, Vishwanath Sharma. I will pay on his behalf. So I am surety. I am telling him one Red Bull. Now, in case the cousin actually shows up to the shop, purchases the Red Bull and doesn't pay for the same, obviously I will have to pay that 125 rupees to the shopkeeper because I was the surety in the whole contract of guarantee. Okay, remember this. I'll come back again on this topic. Okay, in after 2 minutes. Going forward to another example besides the same. This time a different story. This time a different story. So I basically happened to Vishwanath Sharma. I basically happened to visit a shop. We have the same, a cousin of mine. We have again the same, a cousin of mine. Going forward, I already know that my cousin is addicted to Red Bull. I already know that my cousin is addicted to Red Bull. So what I do is, I go to the shopkeeper and tell him, my cousin will come to consume Red Bull. Any number of Red Bulls that he consumes, he might pay for the same. But if he doesn't pay, don't ask for the money. I, Vishwanath Sharma, will pay the money. Can you understand the difference? I'll not mark it for you. You tell me the difference. I'll write this down. I've written for you already. Now you tell me what is the difference that you can see between the two pictures. You will, I will not tell you, although it is very much clear from the diagram, but you will tell me that what exactly is the difference between the left hand side of the photo and the right hand side of the photo. You will tell me, I am not going to point it out. It is very obvious, obviously. Please tell me, I will wait. I will wait. This is as good as spot the difference. This is as good as spot the difference. Sir, what is the difference between the two pictures? What is the difference between the two pictures? Waiting for your answers. I am not going to answer. I am not going to answer. Meanwhile, I'll just write down the names: principal debtor, creditor, surety, principal debtor, creditor, surety. Okay, I will wait for you to message me the difference between the two pictures. As of now, I have one answer which is from general content who says more number of Red Bulls in the second case. Okay, anyone else? Anyone else? Apart from one answer that I've got from general contents, anyone else do I have? that is it. That is it. No other. No other. Okay, I'm marking the difference for you. I'm marking the difference for you. Nandini says, in first case, you have guaranteed the shopkeeper to pay only for one Red Bull. Nandini, very good. This is what I was expecting from your side. One, any number. Such an easy difference between. Such an easy difference between. Over here we have written 1. Over here we are writing any number. So what is it that you are trying to tell us? What I am trying to tell you is, this is specific guarantee. This is continuing guarantee. Sir, why so? Sir, why so? How exactly do you differentiate between the two? See, the only difference between the two, number of transactions. Number of transactions is the only difference. Over here we have 1, over here we don't have any limit. Or one side we have specified 1 Red Bull, 1 transaction. Over this side there are no specified number of transactions. Number of transactions not specified. Over here they are specified. This is the difference. This is the difference. Aisha says, in first case he is liable for 1, in second he is liable for more than 1. Okay, acceptable answer. But the best answer that I got was from Nandini. The best answer that I got was out of all was from Nandini, who said to me, sir, in first case you have guaranteed the shopkeeper to pay only for 1 Red Bull. But in the second case, we don't know. It can be 1 Red Bull, it can be 2 Red Bulls, it can be 5 Red Bulls, it can be hundreds of Red Bulls. We don't know. That is, number of transactions are not specified. Here they are specified. I hope it is clear. I hope it is clear. Then all of this. Then next point. Let's try and recall the same without looking into the book. If your question paper happens to come easy, in that case you can expect such type of questions, which is difference between contract of indemnity and contract of guarantee. In case your question paper happens to be easier, such questions will be asked. The difference between contract of indemnity and contract of guarantee. Let's try and find out at least 2-3 points on our own without looking into the book. Easy points. The first one, the easiest point would be the meaning. Obviously, first point would be the meaning. Okay, first point is the meaning. Second point, such contract of indemnity involves 2 persons. That is, one is indemnifier, the other is indemnified. Insurer, insured. Promisor, promisee. On the other hand, sir, the contract of guarantee involves 3 persons: principal debtor, creditor, surety. It's the second difference. Let's come to the third one. Sir, contract of indemnity is prima facie concerned with to make good the loss. To make good the loss. To indemnify you against the loss. To compensate for the loss. That is basically reimbursement of loss. On the contrary, contract of guarantee is basically security that you are giving to the creditor that your payment is something which is secured and your payment will be made. So one is basically for security. This contract of guarantee is for the security given to the creditor, and over here contract of indemnity basically it is reimbursement of loss. So I think these 3 are the easiest point that you can have. The first was meaning, the second was number of parties, the last one was the purpose. Let's come to the next difference between. Again, something very easy. You can do it even without looking into the book. I'll come to point number 4 here in front of you. Point number 4. Sir, as far as contract of indemnity is concerned, all the parties must be competent to contract, as in major, sound mind, and not disqualified. As far as contract of indemnity is concerned, all the parties must be competent to contract. But as far as contract of guarantee is concerned, principal debtor can be a minor. Principal debtor can be a minor. Sir, why? Because we have studied this already. A minor can always be a beneficiary. We have studied this already. That's a minor can always be a beneficiary. And hence I'm saying this. That's in contract of guarantee, principal debtor may be a minor. Sir, what about others? What about others? What about the surety? What about the creditor? Obviously, they ought to be competent to contract. They must be major. They must be sound mind, not disqualified. For them, it remains the same. What changes is, sir, the principal debtor can be a minor because a minor can always be beneficiary to a contract. So I personally feel these 4 points are those points which you cannot miss out. These 4 points you just cannot miss out. Let's see. We have done this one, this one, this one, and this one. 4 points we have done already out of 7 that we have. Without even looking into the book, only conceptually, whatever we studied till now, based upon that, we could do these 4 points. Are we clear with these 4 points? Please let me know. I will wait. Please let me know. I will wait. Are we clear with these 4 points? Waiting for your message. Waiting for your message. Are we clear with these 4 points? I'll wait for 15 seconds maybe in case I happen to get a reply from 6-7 of you, those who are replying. These 4 easy points. Meanwhile, I move forward. By the time you reply, we have a buffer. By the time you reply, I will move forward because time is very important for us. The next one. Again, a very easy point. Message from Aisha, yes. Message from general contents, yes. Clear, sir. Okay. Thank you. Thank you for the reply. Nandini says, yes, sir. Thank you so much, ma'am. Okay, moving forward. Again, one more easy point, which is time of liability. So obvious, sir. In contract of indemnity, only when that contingent event happens, that uncertainty happens, only then the insurance company will pay. Only then the insurance company will pay. And as far as contract of guarantee is concerned, only if principal debtor defaults, then surety's liability will come into existence. I would again say one of the easy points we have is this point number 5. It says liability in fact arises only on the happening of contingency. Example, sir. Example would be accident of the car. Accident of car. Now that is this contingency which has happened, which will lead to liability of the indemnifier, the insurance company. Now, as far as the contract of guarantee is concerned, only if the debtor defaults, only the principal debtor is defaulting, then only surety will be paid. Sangeeta says, yes, sir. Okay, let's move forward. Time to act. Time to act. So obvious it is. Once the insurance company knows that the accident has happened, once the insurance company knows that the accident has happened, it will automatically start carrying out its work, which is it will appoint a surveyor. The surveyor will come, he will assess the loss, he will make an estimate, the car will go for the service, it will be getting serviced, then the payment will be released, everything will be done automatically. But as far as contract of guarantee is concerned, it is so obvious that debtor will have to tell the surety that, brother, I will not be able to pay the money, please pay on my behalf. Debtor will have to notify the surety that, sir, I will not be able to pay, you please pay on my behalf, I will make sure I will pay you later on. And that is time to act. Coming to the last part, right to third party. A very good point over here. This is also called, in case you have studied this unit previously, this is also called right to subrogation. In case you have studied this already, you know this already, subrogation, right to subrogation, which basically means that surety will step into the shoes of the creditor. Previously, creditor was asking for the money from the debtor. Now, because surety has already paid the creditor, now surety will ask for the money from the debtor. So easy and so logical. I'll repeat one more time in case you didn't get me. So the one who was liable to pay was debtor, but debtor could not pay. Hence, surety has made the payment to the creditor. Now earlier, creditor was asking for the money. Now creditor is gone because surety has already paid the creditor. Now creditor is out of the picture. Now it is surety who will swap with the creditor, will replace the creditor, and will, like a creditor, now ask for the money as a surety from the debtor. So easy. So easy. On the contrary, it is so obvious that insurance company cannot sue the person who has met with an accident with me, because there is no primitive contract between the insurance company and the third person. It can happen only if there is an assignment. Only if there is an assignment. In case you find this point difficult, obviously you can move ahead with the other 6 points. And I personally feel the other 6 points are very easy. I'll repeat myself third time. In case your question paper happens to be easy, your attempt happens to be easier, this question may be there. Okay. Moving forward, I'll draw a diagram. Okay. Now, I'm trying to teach you a word. I'm trying to teach you a word which you might not be knowing already. So listen to me carefully. I've drawn a diagram just for explaining that particular word to you, so that you never happen to forget the same again. So what is it exactly? Sir, this is liability of principal debtor. This is liability of surety. Sir, what exactly does this mean? What this means is, sir, as you can see, as the liability of principal debtor is fluctuating, in the same manner, the liability of surety is also fluctuating in the same direction and in the same direction. So obvious it was that the surety has been here for the principal debtor, for the debts of principal debtor. So if the debts of debtor rises, the liability of surety will also rise. If debtor pay off some of the money, his liability will come down. The liability of surety will also come down. Basically, I'm trying to teach you that, sir, this is coextensive. If I happen to frame a statement, a sentence, I would say the liability of surety is coextensive with that of the liability of principal debtor. I'll repeat, the liability of surety is coextensive with that of principal debtor. And here we are. Here we go. Bingo. So easy. So easy. I just, with the help of a diagram, I tried to explain this particular point. Here we go. This was this coextensive. Whatever the liability of principal debtor is, the same follows for the surety. Easy peasy. Let's do the other points. Unless it is otherwise provided by the contract. So if the contract says that no, the limit is there on the liability of the surety, then we'll follow that accordingly. So unless basically means contract to the contrary. So if there is no contract to the contrary, the liability of surety will be coextensive with that of the principal debtor. Easy point. Moving forward. Number 2. So obvious point. So liability of surety is secondary in nature, and he's only liable only default of principal debtor. You can correlate this point with this point, nature of liability. We were yet to discuss this point. Now we can discuss it more clearly. Sir, in case of indemnity, it is only the indemnifier who has to pay. There is nobody sitting on behalf of indemnifier who will pay. So it is only the indemnifier who is bound to pay, and hence primary and unconditional. Primary and unconditional. But as far as contract of guarantee is concerned, sir, it is secondary and conditional, the liability of the surety. Sir, why are you saying so? Sir, I am saying so because the word secondary, because primarily principal debtor has to pay. Primarily principal debtor has to pay. If he doesn't pay, then I as a surety pay, and hence the word secondary. And the condition is also there. In case principal debtor defaults, then surety will pay, and hence we see the words secondary and conditional. Secondary and conditional. Primary and unconditional. Here we go. I hope now we are more clear with both difference between as well as the point. Vanakama says, sir, please explain first point. Did you understand this concept? Did you understand this concept? The liability of the principal debtor and the liability of the surety are going hand in hand. And that is something called coextensive. I hope we are clear now. Vanakama, I hope we are now clear. This is coextensive, going hand in hand. I hope we are clear. Third point is again the same. Sir, let's say if there is a defect in document, let's say it is invalid stamp duty. In that case, debtor will be discharged. Now, because debtor is being discharged, surety will also be discharged. There we go. When a debtor cannot be held liable on account of any defect in the document, the liability of the surety also ceases. I hope this is again a very easy point. It is very much similar to the topic of coextensive. Okay, very much similar to the coextensive point. And the last one, something I could say the easiest of them all. A creditor may choose to proceed against a surety first. A creditor may choose to proceed against the surety first unless there is agreement to the contrary. Now, if the creditor is already knowing that debtor has gone insolvent, why would he proceed against the debtor? To directly go to the surety and take the money. And that is your 128. Not very important, but like I said, we will be doing the whole of unit number 789 completely. Although a bit fast, but yeah, we'll try to do everything of unit number 789. Next, 132. Again, not important, but we'll discuss it orally once. Sir, if the sureties agree between themselves, that one of them will be liable only in case of others default, or surety one will be liable 30%, surety two will be liable 70%. Lawmaker says creditor will not give a damn about this contract. That what is exactly happening between surety one and surety two. Creditor can proceed against surety one. It can proceed directly against surety two. Anyone that creditor wants, he can proceed against. Now, surety one and surety two cannot say, S1, S2 cannot say to creditor that no, S1 will pay 30%, I will pay 70%. No, creditor is not affected by the contract between the sureties. Creditor can proceed against anyone and ask for the whole of the money. Not very important, 132, will not go much into it. Now here comes a very important topic. General contents, you are asking, important topic. This is the important topic. Discharge of surety, sir. This is important. I hope you are still there. General contents. I can see your DP to be of Mahendra Singh Dhoni. I hope you are still here and listening to that important question that you were asking for. This is the important question. Discharge of surety. Okay, he says yes, I am here. Nice. I'm giving you some mnemonics. I'm giving you some mnemonics. This is a theory question, 4 marks, and both of these are practical questions. Both of these are practical questions. Okay. Coming to the mnemonics, this is MCA. This is MCA. This is notice of birth and death. Notice of birth and death. The last one, CID variation. CID variation. So basically we have 10 points. What we'll now cover is this much. Because the other two topics are huge topics, I need almost 40-45 minutes that we don't have. So we'll try and cover this last box, which is very important. It was there in June 2024 attempt. Although practical question was there, but I expect a theory question from this point, which is by invalidation of contract of guarantee. MCA. Sir, what do you mean by MCA? Misrepresentation, concealment, and joining of another co-surety. Do you remember we did a topic called features of contract of guarantee, and I told you point number 4 and 6 will repeat. I told you point number 4 and 6 will repeat. They have now come. This 4 is there and this 6 is there. So what is point number 4? What is point number 6? Please listen to me very carefully. It says M. Okay. It says, sir, if creditor does any misrepresentation with the surety, in that case, surety will be discharged. His liability will end. His liability will end. The next part, C. If creditor does any concealment with the surety, concealment as in he's hiding something, So if there is any concealment, again the result is the same, sir. Surety is discharged. M and C. Let's come to the last one, that is A. Here what we have is a creditor is there and we have two sureties, surety 1 and this surety 1 is saying that I am ready, I agree to be a surety, only if, as in we have a condition, only if surety 2 joins in. So surety 1 says, I am ready to be a surety, I don't mind being a surety, but I just have one condition, which is surety 2 shall also join. Now what happens is, this surety does not join. Surety 2 does not join. Lawmaker says, in that case, surety 1 is discharged. I will repeat the point for you. Point number 3, which is A. Point number A, I will repeat. Listen to me carefully. It is very easy. Surety is ready to be a surety. But he just has a condition which says, I want someone else also as a surety. So I will be a surety provided that another person joins in as a surety. but that other person does not join. Now, because that other person does not join, the condition is not fulfilled. Now, because the condition is not fulfilled, surety 1 will be discharged. Surety 1 will be discharged. This was section number 144. This was section number 144. And here we go. This is your MCA. Here we go. By invalidation of contract of guarantee, misrepresentation, then we have concealment, and then we have another person joining in. Creditor shall not act on it until another co-surety joins, section 144. Here we are in front of you, the diagram. Please tell me if we are clear. Please tell me if we are clear till now. If we are clear till now. I will wait for your messages. I will wait for your messages. Are we clear? Are we clear? The 2 points. I have around 13 to 15 watching on YouTube live and others on Zoom. I'll wait for your messages. Are we clear? MCA, a theory question which I am saying I'm expecting it for your exams in your January attempt. In your January attempt. Okay, Nandini says yes, sir. Okay, fine. Varnakama says, sir, second point. C. Second point basically is talking about concealment. When I say concealment, this basically means you are hiding something. Concealment basically means you are hiding something. So as a creditor, if you are hiding something from the surety, see, ultimately the whole topic is for the creditor, that you should be safe, your money should be safe. The whole topic is revolving around creditor. Now this creditor himself is hiding something from the surety, not telling him something, hiding something from the surety, that is concealment. In that case, it is there, then surety will be discharged. So creditor cannot hide any facts from the surety. I hope we are clear, Varnakama. I hope we are clear. Please tell me. I'll wait for your message. I hope we are clear. Then we have Kiran. Kiran says A not clear. Sir, A point basically says you cannot lie anything. You cannot say a lie. You cannot say something wrong, which is representing yourself against the surety as a creditor. You cannot say something wrong to the surety. In case you do it, the surety will be discharged. In case you do it, the surety will be discharged. Are we clear now, Kiran? You had a message not clear. I hope it is now clear. Because still, as much as I remember, question number 1A was from this topic in June 24. See, this was the question. With regards to misrepresentation, see, here's the line. R demands a guarantor for the transactions. S, a friend of P, came forward and gave a guarantee for payment of water purifier. Okay, this is basically the main question. Now, the topic. R sold the water purifier, misrepresenting it as having a copper filter while it actually has a normal filter. Can you understand this line? Kiran says now clear. Wow. Kiran says now clear. What I'm trying to tell you is, sir, this is outright misrepresentation. This is misrepresentation. And like we just discussed in point MCA, in case of M, if we have misrepresentation, the surety is discharged. So can you understand this June 24 question worth 7 marks? That's because of misrepresentation, the surety will be discharged from his liability to pay to the creditor. Are we clear? Are we clear? This is misrepresentation. I'll show you the answer. By the time you can just tell me if we are clear with this point. If we are clear with this point. Here we go. I'll mark 142 first. The conclusion invalid. The conclusion invalid. Are we clear? Okay, we have answer already. We have an answer already from Kiran who says discharge. I'll wait for others. This was your examination question asked in June 2024. What about others apart from Kiran? Are we clear? Are we clear? Apart from Kiran, are we clear? June 24, it was compulsory question, 7 marks. Are we clear? The next two boxes are huge topics. I will need around 30-40 minutes for the same, which I don't think we have right now. Vanakama says yes sir. General content says yes sir. So what we'll do is tomorrow we'll try and complete the whole of unit number 7 and start with unit number 8 as well. Tomorrow we'll end lecture early right now. I'm ending it right now. What we'll make sure is we'll meet tomorrow 7:30 at the same time, but we'll try and complete the whole of unit number 7 and partially unit number 8. So for the time being, I think I will end the session because the topic is very big. I'll need 30-40 minutes, which we don't have. So yeah, we end the session here. Expecting you understood everything that we learned today, many questions we studied today, lots of topics we covered in a merely 1 hour 45 minutes. Expecting if things are clear, we can end the session now. We can end the session now. Are we clear? Are we clear? You can just revise all the topics on your own once after the lecture is over so that you can remember it forever. And not just a short-term memory, but a long-term memory. So you can obviously revise these topics once the lecture is done on your own also. So in case you permit me, we shall end the lecture over here and try and finish unit number 7 and partially unit number 8 tomorrow. General contents, yeah, okay, bye. Okay, bye. Shall we end? Okay. Ending the session then. Bye. Yes, I'll show you the answer once, obviously. Here is the answer. Here we go. The answer. Yeah, Nandini, thank you. Bye. Shall meet tomorrow. Shall meet tomorrow. Okay, we end here. I hope you have seen the answer, Kiran. I hope you have seen the answer. Okay. Okay, thank you. We end here. Okay. Hold. So, yeah. kami maklum